Hi, my name's Jane Mcelligott. I'm a full-time faculty member with Legal Support and Services here at Purdue Global. And I am here to discuss what is being called the Bad Spaniels case that was just decided in June of 2023 by the Supreme Court of the United States. So to take a quick look at the facts of this case, it involves Jack Daniel's whiskey and a dog toy that is a parody of Jack Daniel's whiskey. And so if we take a quick look, this should help. Let me go to the next slide. So on the left is a bottle of Jack Daniel's Tennessee whiskey, and you can see all of the different the appearance of it, the wording is pretty much mimicked by the Bad Spaniels dog toy, which I happen to have right here. So a consumer could tell the difference by looking. I mean, this is soft and rubbery, but it does pretty much follow along with the trademark, if not exactly take the trademark in different spots and just change it a tiny bit. So what happened was that, let me go back to our facts here. So Jack Daniels sued VIP Products, which is the manufacturer of the Bad Spaniels dog toy. And they make a lot of dog toys, really parodying, making a parody of other liquors and foods and, coffee, popular products for humans. And so in this case, it went up to the Ninth Circuit Federal Court of Appeals. And that court held that VIP Products was entitled to First Amendment protection. And this is their argument that, this is an expressive work, a parody. So much like a show like Saturday Night Live takes off, say, a politician, that would be a parody. And the same thing can happen in the area of trademark law. It's just kind of poking fun at a product. It's not trying to write off the coattails of the manufacturer of that product. And so that's the argument of VIP Products in this case. And so they prevailed at the Court of Appeals level. Jack Daniels, though, not too happy at that decision, petitioned the Supreme Court to hear the case, and the Supreme Court agreed. So it went before the court. Justice Kagan wrote the majority opinion. It was actually unanimous opinion, 9-0. And they held that Bad Spaniels does not get a free pass for parody under the First Amendment. And of course, the First Amendment, the free speech. But they said that it used to be many cases, and we'll look at one example. There are many other cases like this where the courts usually say, oh yeah, you're just poking fun at the product. It's not trademark infringement. But this is a little bit different because, as we can see from that picture, the trademark, basically VIP Products use the actual trademark of Jack Daniels to poke fun at Jack Daniels. And so in the words of Justice Kagan, a bottle of Jack Daniels, no Jack Daniels Old No. 7 Tennessee Sour Mash Whiskey, because every type of product has its own trademark. It's just a huge lineup of trademarks, but saying that boasts a fair number of trademarks, even just that one bottle. Jack Daniels is the registered trademark. The Old No. 7 too is the trademark. The arched Jack Daniels logo, the stylized label with the filigree, that twirling white line that we can see. We'll go back to the picture in a second. And so really what might be thought of as the platform for all of those marks, the whiskey, is that the whole look of the bottle is itself registered as a trademark. And that's an interesting concept, because if you think of Coca-Cola, the old-fashioned bottles, the glass bottles, that in itself, that style of the bottle is a trademark. So everything about a product can be a trademark if it's unique in its own way, and really something that consumers would recognize as being from that manufacturer. So there are the two of them again. And so again, as you can see, if you really analyze what the court is looking at, so exactly where it says Jack Daniels, they have Bad Spaniels. where Jack Daniels has the old number 7. They have the old number 2 on your Tennessee carpet. And so poking fun at Jack Daniels in a way that's could be looked at as quite disparaging for Jack Daniels. Jack Daniels didn't find much humor in it, especially because if you really look at the small print, it says Jack Daniels states that its product is 40% alcohol by volume. Bad Spaniels says it's 43% poo and 100% smelly. So again, really kind of, disparaging it in that sense. And everything about it is an exact, almost a mimic of the trademark. And so the court went on to say that the key purpose of trademark law, which is covered under the federal law, the Lanham Act, its purpose is to prevent consumer confusion over the source of the product. So, for example, the particular bottle shape of Coca-Cola, you would see a consumer would see that and would know it's Coca-Cola, not Pepsi, for example. So the risk of consumer confusion, as the court points to, is that at its highest when a company actually uses the trademark as a trademark, as VIP did in this case with Jack Daniel's bottle. And so because it's so much alike and so blatant use of the trademark, that they can't just count on parody under the First Amendment to come to the rescue. The court did say this is a very narrow exception because usually a toy maker, oftentimes a dog toy maker, doesn't make it this much alike. This is kind of unusual that it's this similar in every shape and form. And so part of the court's worry was that would consumers think that Jack Daniels itself made this dog toy and kind of disparaging itself? It's not clear. Consumers might see this and say, oh, it looks just like the Jack Daniels whiskey. They must produce dog toys too. So again, it leaves that the origin of the source kind of maybe confusing for consumers in that sense. So SCOTUS then remanded the case to the trial court, which is it's heading back down to the trial court right now. And the trial court will be applying what's called the likelihood of confusion test. So each federal circuit has its own list of likelihood of confusion factors. And the court will apply these so that when a company alleges that another company is infringing on its trademark or diluting, taking away the strength of that trademark, the court has to look at certain factors such as what's the strength of the plaintiff's trademark. If it's a very strong trademark, then maybe anything that's coming too close to it could be looked at as trademark infringement. They also look at the similarity of the products, and here some of these factors could go in. Ultimately, VIP products could prevail because you have whiskey and a dog toy, so they're not in the same channels. The likelihood of actual confusion, again, if you picked up this dog toy that's all rubber, it would be tough to say this is one. I would think that this is made by Jack Daniels, but again, it's up to it's up to particular individuals, and the court would have to look at that. So instead of just granting that free pass under the First Amendment, the court will have to first apply the likelihood of confusion factors. And so it's at this point, it's not to say that VIP lost, but they have a little bit of a road bump to go over in order to win. But really, what got VIP products into trouble is just going so close, using the same shape bottle, the same filigree, as they call it, on the bottle, just making it appear almost, if it wasn't for the different feel of the bottle, one might think it's the same exact product. And the fact that it's disparaging, many think it's funny, but it also could be looked at as disparaging especially by Jack Daniels. to compare that case to an earlier case, this is a 2007 case decided by the Fourth Circuit Court of Appeals, a different federal circuit. And this involves Hot Diggity Dog, a dog toy manufacturer that came out with a line of kind of a mix of toys and purses, pocketbooks for dogs. As you can see there, that dog is sporting a little purse, a Chewy Vuitton. And so, of course, it pokes fun at Louis Vuitton, the exclusive handbags from Paris. And so you can kind of see one of the differences here is that instead of disparaging the whiskey as as VIP products was doing to Jack Daniels, here it's Chewy Vuitton is kind of saying, "Hey, look at this dog with the Chewy Vuitton purse," like kind of giving a positive spin, even a more positive spin to Louis Vuitton, because we always think, "Oh, look at that, they have a Louis Vuitton purse." So it's more of a positive likening to the product in this case. So in this case, Louis Vuitton though didn't like Chewy Vuitton using somewhat similar of a name, so they sued. And the big question is, did Louis Vuitton win? Actually, it was a win for the dogs. So Chewy Vuitton won. And mostly because their products, again, now this is a parody. This is a pure parody of Louis Vuitton products. And the court said that there is no consumer confusion here, that a little dog purse there, clearly with Chewy Vuitton, would not be confused with a Louis Vuitton purse. And also a factor in this was Chewy Vuitton actually registered a trademark for Chewy Vuitton. So it's kind of interesting that this case, again, this was back in 2007, and this was never appealed to the Supreme Court. This is the first time a case like this has made it to the Supreme Court. But this case will probably still be this case itself, of course, is already decided, and it will probably stay solid law. It's probably only in the case where you have there's another Chewy Vuitton, when you have a dog toy manufacturer or any other kind of toy manufacturer poking fun in a way that is just basically using that the trademark of that company as its own trademark, basically. And so in this one article, I think they did a good job distinguishing the two cases. In the Hot Diggity Dog case, Chewy Vuitton did not comment on the quality of Louis Vuitton goods. Indeed, the fact that Louis Vuitton makes luxury products directed to people with high tastes and higher budgets was really kind of part and parcel of the joke, that, oh, look at that classy dog with the Chewy Vuitton. So it almost elevates the Louis Vuitton name. But then when we contrast that with the Bad Spaniels, where it's, associating Jack Daniels, their premium whiskey, with dog poop on the Tennessee carpet. So in the end, and again, we'll kind of have to see how this case goes through the trial court. But while parody is not off the table for dog toy companies, again, it's okay to poke fun at human products. But it might be the case from now on that they don't just get this free pass. And instead, they'll have to face the likelihood of confusion factors. And again, these are the factors here in the Ninth Circuit, which is where this case was decided. So again, the strength of the plaintiff's mark. So of course, Jack Daniels, the mark is very strong, which would help Jack Daniels. The similarity of the marks it's very similar. The marketing channels used, that would differ. I mean, the marketing channel used for liquor is going to be quite different from the channel used for dog toys. Is there evidence of actual confusion? They can actually do opinion polls of people to see, were they confused about the source of this dog toy, mimicking Jack Daniels? And the defendant's intent in selecting the mark. So was VIP products, were they trying to ride off the coattails of Jack Daniels in coming up with this product, or is it just poking fun? So that would come into play as well. The likelihood of expansion of the product line. So might Jack Daniels have expanded into the area of dog toys itself, and now VIP products has taken that away? So that's another factor. And also the type of goods and the degree of care likely to be exercised by the purchaser. So again, if one buys Jack Daniel's liquor in a liquor store, they're not going to be seeing dog toys in the liquor store. So really the product line, the channel, the marketing channels are different, and likely the consumer would not pick up a bottle of Bad Spaniels and think they can drink it. So it seems as though ultimately, perhaps VIP products may win the case at the end of the day, but it does set a new standard, a narrow standard again by the Supreme Court that perhaps the parody is not always just a free pass to getting out of trademark infringement or trademark dilution cases. And that is the end. So thank you very much.